Major development in the lawsuit against gunmaker Remington. Now that company, it made the AR-15 semi-automatic rifle, the same rifle that was used to kill 20 children and 6 adults at Sandy Hook Elementary School. The shooter got off more than 150 rounds. Now the suit by family members of those victims says that Remington should be held responsible as its product is specifically made to kill lots of people as fast as possible. Remington, in response, says it has immunity from prosecution because of a federal law passed in 2005, a law that insulates it from criminal misuse of their product. In effect, Remington says, we make it, we're not responsible for what people do with it. Now, Remington has filed a motion to dismiss the case, but surprisingly, at least to some, the judge at the state level in Connecticut has ruled that the case can, in fact, move forward. Mark, how significant is this?
Well, it's hard to say how significant it is legally because the refusal to dismiss a complaint outright is very different from a finding of liability. But from what I gather, it's not only Remington that's been sued, but also the store and whoever the middleman is between Remington and the store that sells it. And the theory that the plaintiffs are pursuing is that the defendants are not immune if they knew or should have known that they were selling to a bad apple, which would be the mother, allegedly, in this case. So
well, if Remington made the case, I think they have a fair point to say, wait a minute, we produced the gun, we manufactured it, we gave it to the distributor. Right. The distributor even said, when the person came in here, they passed the background checks and they got the gun. Their contention seems more the make and model of the gun, in that there was no discernible purpose for this gun other than to shoot a lot of rounds in a short period of time. It's not a hunting rifle. It's really not used as a home protection rifle. It's an assault weapon by definition. Is that a distinction with a difference?
Well, from what I gather, the judge didn't reach that question, and from what I can glean from this, they're going to allow discovery, the exchange of documents and depositions and such, probably to see who knew what and when they knew it with respect to selling to a risky person.
And how chilling, or how much of a stopper, if you will, is that you have a federal law on the books. I may not like the federal law on the books, but it's clear. The one industry in this country that is exempt here and it gets immunity is the gun industry. Is it shorthand to say Connecticut can do whatever it wants, but at the end of the day, federal law trumps? Well,
I mean, they're applying, a state court is applying federal law in this case because you can bring the suit in either forum. Obviously, the plaintiffs would have chosen to bring it in a more sympathetic venue. You can't read too much into it in this point. It's a preliminary ruling at a lower trial court level. There'll be 2 levels of appeals if there's a finding of liability. There are multiple defendants. Probably Remington and the distributor will be thrown out at what we call the summary judgment stage before trial. The seller, the store itself, may have a bigger problem, but that's not where the deep pockets are. So,
you know, for me, if you can imagine a time where the almighty buck gets introduced to this equation, and now manufacturers have to say to themselves, where am I going to get the most trouble here? If I make a gun here, where people are going to have a hard time arguing that can be used for anything, and who is the target audience for this? The margins for me, forget the ethics, might make this not worth it to be in the business. That's how this conversation can change, right?
Well, I tend to think if you look at this and you put it in a different arena, let's assume you're talking about alcohol and you have some of these high-proof alcoholic beverages, maybe it's a 151 or something like that, and you say, well, it's different than sipping a glass of wine. You only drink this if you want to become intoxicated. So someone drinks it, becomes intoxicated, goes out, has a fatality vehicle accident. Do you now hold the alcoholic beverage manufacturer liable for that? That's the same question. So I think it's very different than a dram shop rule where you're saying, okay, this bar saw this person's already 3 sheets in the wind and they gave them more alcohol anyway. That's a different situation. So really, again, to Mark's point, it's premature for it to be dismissed outright. There are a lot of different components to this case, but when it gets to the motion of summary judgment, it's going to be difficult for it to be sustained.
And what happened a couple of weeks ago in what they call a per curiam opinion, an opinion that the Supreme Court issued without argument or briefing on the merits, they threw out a ruling in Massachusetts that restricted Second Amendment protections for firearms, and they took sort of an easy way out of it, saying send this case back to Massachusetts for better findings. But even with a 4-4 court without Scalia, they're showing no inclination right now to revisit the Second Amendment as it exists. They just said, you're reading it too narrowly in Massachusetts, go back and do what we said in Heller and the Chicago case.
Legislature needs to act here, is what needs to happen, because the question for me is, why is it okay to sell an assault weapon like that?
And we've already seen, and we had a law on the books. Chris Shade's frequent guest was one of the authors, co-authors of the bill, that we had an assault weapons ban in this country. That's sunset. It's still here. So, as you said, the legislature can and has in the past played a role in these things.
Because if it gets to a jury, we know what's happening.
Absolutely.
Right, well, what they said in the other case, if this is the kind of weapon that's in common circulation, you can't ban it. So if people are using these assault weapons now today,
AR-15s are in common
it.
circulation.
Please.
Coming up next, table weigh in on those religious freedom laws that are always in the news. Now, they aim to protect people's religious rights, but the critics say they also can discriminate against, among others, gays and lesbians. So the question is, how can a state essentially rewrite the Bill of Rights?